Introduction. General abstention from the criminal liability are crucial elements of the criminal justice system, ensuring that justice is administered fairly by acknowledging situations where an individual actions, though typically criminal, are justified or excused. These exemptions, which include infancy, unsoundness, intoxication, consent, mistakes, accident, necessity, threat, and private defense. These abstentions reflect the law's understanding that context and personal circumstances significantly impact capabilities.
Infancy refers to a legal doctrine that exempts very young children from criminal liability because they are presumed incapable of forming the intent necessary to commit a crime. The specific age at which a child is considered to be legally incapable of committing crime varies by jurisdiction but is often set around 7 to 10 years old. Children below this age threshold are generally considered incapable of criminal intent and thus cannot be prosecuted in the same way as adults. For the infancy, the law is section 113A, 82 PC, and 83 PC. The principle of doli incapax, meaning incapable of wrong, presumes that children below a certain age cannot be held criminally responsible because they lack the capacity to understand right from wrong or the consequences of their actions. Typically applied to children between infancy, example under 7, and a higher age limit, example under 14. Unsoundness refers to a state of mind in which an individual is unable to understand the nature of their actions or distinguish right from wrong due to a mental disorder or defect. This condition can exempt a person from criminal liability as they are considered incapable of forming the necessary intent to commit a crime. For instance, a person with severe schizophrenia who experiences delusions and hallucinations might believe they are acting under divine command when committing a crime. Due to their unsoundness of mind, they may be found not criminally responsible for their actions, as they are unable to comprehend the reality or illegality of their conduct.
The intoxication in the context of criminal law refers to a state in which an individual's normal capacity to act or reason is inhibited by the consumption of alcohol, drugs, or other substances. This condition can affect a person's ability to form the intent necessary to commit a crime. There are two types of intoxication considered in law: voluntary and involuntary, which has the law section 851 and 852. An example of involuntary intoxication might be if someone is at a party and another person secretly adds drugs to their drink, causing them to become highly impaired. If the intoxicated person then unknowingly commits a crime, such as vandalism, they might claim involuntary intoxication as a defense, arguing that they were not in control of their action and did not have the intent to commit the crime. Consent in the context of criminal law refers to the voluntary agreement or permission given by a competent individual for something to happen or be done. For consent to be legally valid, it must be informed, freely given, and not obtained through coercion, fraud, or undue influence. An example of consent in criminal law is in the context of physical contact sports. For instance, when individuals participate in a boxing match, they consent to the physical contact and potential harm that may occur within the rules of the sport. If one boxer punches the other within the agreed upon rules, it is not considered a criminal act because the participants have consented to the contact.
Next, I'll talk about mistake. The mistake is an incorrect understanding or belief about a fact or law that leads to a person to commit an act that would not have been committed if the true situation had been known. Mistakes can be classified into two main types, which is mistake of fact and mistake of law. The mistake of fact occurs when a person has an incorrect belief about a factual situation, whereas the mistake of law involves a misunderstanding or ignorance of the legal principles applicable to situation. This commit to law will go under section 76 and 79. For example, a person takes an umbrella from a restaurant's coat rack, believing it to be their own due to its similar appearance to their own umbrella. Later, it turns out that the umbrella actually belongs to someone else. This is a mistake of fact because the person had an incorrect belief about the ownership of the umbrella, and this belief negated the intent to commit theft. Next, I'll talk about accident. In criminal law, an accident refers to an unforeseen and unintended event that occurs without any deliberate intention to cause harm or commit a crime. An accident is typically characterized by a lack of criminal intent, negligence, or recklessness on the part of the individual involved. For instance, if someone is walking down the street and accidentally bumps into another person, causing them to fall and break their arm, this would be considered an accident. The individual did not intend to cause harm and had no malicious intent, making it an unintentional and unforeseen event.
Necessity. The necessity defense is a legal principle that exonerates individuals from criminal liability if they commit a crime to prevent a greater harm from the recurring. It is based on the premise that an illegal action was necessary to avert an imminent and insignificant danger. There were no reasonable legal alternatives available. The defense requires the harm caused by the criminal act is less severe than the harm sought to be avoided. Necessity comes under the Section 91 law. A classic example of the necessity defense is a situation where a person breaks into a cabin in the woods to seek a shelter during the snowstorm. If the person had not broken in, they would have faced the imminent threat of the hypothermia or death. In this case, the necessity defense could be used to argue that an illegal act of the breaking and entering was justified to prevent a greater harm. Duress. Duress is a legal defense in the criminal law where an individual argues that they are committed a crime because they were coerced by another person through a threat of immediate danger to themselves or others. The threat must be of such a nature and that is overcome the individual's will, leaving them with no reasonable opportunities to escape or resist. An example, duress is when a person is forced to rob a bank because someone is holding their family hostage or threatening to kill them if they do not comply. In this situation, the person commits the robbery under the immediate threat of the harm in their loved ones, making duress a viable defense.
Private defense. Private defense is also known as self-defense. It's a legal doctrine that allows an individual to use reasonable force to protect themselves, others, or property from an imminent threat or unlawful attack. The force used in private defense must be proportionate to the threat and necessary to prevent harm. If someone is attacked by an armed robber, they are entitled to use reasonable force such as striking the robber or using a weapon in self-defense to protect themselves from injury or death. This action taken to prevent imminent harm who would typically be considered lawful under the principle of private defense. Incorporating general exemptions from criminal liability into legal system underscores a commitment to nuanced justice where the complexity of human behavior and situational factors are considered. These exemptions not only protect individuals from unjust punishment but also enhance the fairness and integrity of the legal process, ensuring that each case is judged on its unique merits and circumstances.